Public Inquiries, a New Era for Recommendations, question mark. Kiva and I had a great debate about whether this was too grand a title, promising you too much from this webinar, but we think it's justified, and we think that we can say that we're in a changed environment for inquiry recommendations, and we'll explain later in the webinar why we think that is the case. I think the key takeaway that we'd invite you to take from the webinar is that inquiry recommendations now feel much more like the beginning of a process rather than the end of a process, and that in making recommendations, inquiries are continuing to be active rather than moving into a passive or end state. So who are we? If we move on to the next slide, I'm Christine O'Neill, KC. I am the chair of Brodies, but I'm a partner in our administrative and public law team, and I have got a lot of experience dealing with public inquiries, and I currently represent the Scottish Government as counsel in the Scottish Child Abuse Inquiry. My colleague Kiva Hunter Blair is a solicitor in our team, and we work together on a number of public inquiries, including the Scottish COVID inquiry. We have experience of working not just with 2005 Act inquiries, which is what we're talking about mainly today, but also other public inquiries, non-statutory public inquiries, and internal inquiries that clients sometimes have established for themselves. So if we move on to the agenda, what we're going to cover today is an introduction. That introduction is really a refresher for you of some of the basics of the 2005 Act and the inquiry process. It will be familiar to many of you, but useful nevertheless to look at that. And then we'll talk a little bit more about what we're seeing in terms of inquiry recommendations and the shape of inquiry recommendations in the last several years. We'll also say a little bit about when and how you can challenge the decisions of public inquiries, something that turns out to be quite a tricky exercise. And we'll conclude just by reflecting on some parliamentary activity in this space. So I'm going to hand over to Kiva to start us off with that introductory part of the webinar, just giving us a refresher on inquiry law. Kiva.
Thank you, Christine. Morning, everyone. So starting off with a brief refresher of inquiries. Public inquiries are established by the government and government ministers to investigate specific or controversial events. And once they are established, they are independent of the government. And they're inquisitorial and not adversarial, so it's different from a court setting when looking into those events. Public inquiries determine an independent account of facts, circumstances, and reasons as to why something has happened. And a public inquiry will make recommendations. Our focus today, as Christina said, is on the statutory inquiries, which we'll come on to talk about, but very briefly, setting out a difference of the two. So the non-statutory public inquiries do provide a greater flexibility on procedural rules because they're not governed by the Inquiries Act of 2005. And this can make it easier to hear privately, if necessary, evidence which is more sensitive, for example, for national security reasons. And a key difference is the powers of a non-statutory inquiry. So they don't have the power to compel, for example, the production of evidence. And so if we can move on to the next slide, we'll move on to statutory inquiries. And so the 2005 Act provides the framework through which statutory inquiries are established and how they are run, together with the Inquiry Rules 2006 and the Inquiries Scotland Rules 2007. Statutory inquiries, which we'll just refer to as public inquiries from now on in the presentation, have the power to compel witnesses to provide evidence and can provide certain legal safeguards. So, for example, if you're compelled to provide evidence and there's a Section 21 notice that can provide safeguards for example, GDPR purposes and any concerns that you have with disclosing that information. statutory or public inquiries also have the power to award core participant status to either individuals or organisations. And the two sets of rules provide a special status for core participants. So, unlike an ordinary witness who may be asked to come and give evidence in an inquiry, a core participant can usually make opening and closing submissions depending on the inquiry, have access to documents and witness statements before they're made public. They can apply to question witnesses at inquiry hearings, and more often in Scotland, that's through the chair or through counsel for the inquiry rather than directly questioning a witness. And they can also obtain a copy of the inquiry's report before it's made public. Um, so these rights are obviously at the discretion of the chair of the inquiry, who's responsible ultimately for how an inquiry is run. So move on to the next slide. And just a brief refresher of the report that's produced by an inquiry and any recommendations. So, a public inquiry firstly can't make any findings of civil or criminal liability, and an inquiry is said to come to an end on the date after the delivery of the report of the inquiry, on which the chairman notifies the minister that the inquiry has fulfilled its terms of reference. There, the recommendations in the report have no legal effect and are not binding, but we'll come on to look at how different inquiries are interpreting that. Um, and the chair of the inquiry must deliver a report which sets out the facts determined by the inquiry, and the recommendations are made if it's provided for in the terms of reference of the inquiry. And I think we'll find more often than not they are included in the terms of reference of the inquiry, and it would be sort of abnormal for them not to be at this stage. So we're going to move on now to sort of look at different examples of inquiries and how they are applying the recommendations they make or following up on any recommendations they make. And I'll pass back to Christine for that set of the slides.
Thanks, Kiva. So, we're going to look at a number of inquiries. The general message is, as I explained at the beginning of the webinar, I think we can say with some certainty that inquiry chairs are being more innovative in their approach to making recommendations than perhaps they have been in the past. And they're being more active in monitoring implementation of those recommendations. And it seems, I think, fairly clear that the rationale for that is a degree of frustration that in respect of public inquiries in the past, perhaps, inquiries have made recommendations that have been passed to governments, whether it's the UK government or devolved governments, and those recommendations may or may not have been implemented. And it does seem to reflect a different vision that chairs of public inquiries have about their own role. In the past, I think it is again fair to say that chairs of inquiries would take the view that their job was to fulfil their terms of reference and hand over their report and recommendations to government, and it was then for government to decide what to do about it. I think inquiry chairs are now of a view that their role goes beyond that, and their role is concerned with the need for public accountability. So the idea that the inquiry and its recommendations should have a life after the inquiry's report, and that there should be accountability of government to the inquiry and to the public for implementation of recommendations. Now, all of this means for you who may be involved in inquiries that there is greater potential for participation, particularly by core participants. And that can include the potential for greater influence over recommendations themselves. But it also means, I think, without doubt, a greater resource burden for core participants and those who are the subject of recommendations, because you are now going to be required much more actively to engage with the inquiry after its recommendations have been made. So if we take some of those in turn, the first is the Grenfell Tower inquiry, which is obviously concerned with the events surrounding the Grenfell Tower fire. Um, Here, the inquiry adopted a fairly interesting approach to the making of recommendations. So when it was preparing those recommendations, it invited a number of organisations, core participants, to produce position statements setting out the steps they'd already taken in response to the fire and to put forward recommendations themselves. And then expert witnesses were invited to give their views on those suggestions. Um, the inquiry then published its phase one report in October 2019, making a series of recommendations. The inquiry said that it isn't monitoring responses to the recommendations. We'll see later that other inquiries are more actively monitoring implementation, but the UK government has itself been publishing updates on progress in relation to phase one recommendations. So by September of last year, according to the UK government's website, 39 of the inquiry's 46 phase one recommendations had been completed. No doubt views will differ on just how adequately those have been implemented, but that's the UK government's position. And the website goes on to break those 46 recommendations down into those that were directed specifically at the government and those that were directed at other organisations. I haven't seen or been able to find an equivalent for the phase two report that was published in September of last year, but this is an example of a much more active approach to the formulation of recommendations and then a more active response by government in updating on what it's doing in response to those recommendations. That has, if you like, been further developed by the infected blood inquiry. So if we move on to the next slide, you'll see, and I'm sure you will know that the terms of reference included that the inquiry was to make recommendations as well as examining the nature, adequacy, and timeliness of the response of government. Now, that was the nature, adequacy, and timeliness of the response of government to the infected blood crisis itself, rather than the response to the inquiry's own recommendations. But when it published its final report in May of last year, the inquiry said in relation to delay, and particularly in relation to delay in the implementation of recommendations, that that delay not only causes frustration, but compounds the harm and suffering many of those infected and affected have endured. And that has been a consistent theme in the infected blood inquiry and the desire of the chair to, if you like, hold the government's feet to the fire in terms of implementation. So in the final report in May of last year, the chair set out various recommendations, and in relation to the conclusion of the report, and this is section 14 of the 2005 Act, and Caoimhe has already mentioned when an inquiry comes to an end, what the chair of the infected blood inquiry has said is that the inquiry ends not with the delivery of the report, but when the chair notifies the minister that their terms of reference have been fulfilled. And the inquiry chair here has taken the view that that will not be done until there is a response to some of these recommendations. So the slide sets out the approach that the chair took to implementation. And what we know is that by December of last year, the UK government had published a lengthy response to the recommendations that had been made by the inquiry chair. And it's also interesting here that the chair of the inquiry recognises that his role will eventually come to an end and he will not necessarily be able to carry on making sure that his recommendations are implemented. So one of his specific recommendations was for, if you like, another monitoring mechanism, and that was to ensure that the Public Administration and Constitutional Affairs Committee should review the progress of responding to the inquiry's recommendations and implementation of those recommendations. So Not only is the inquiry itself trying to keep a watching eye over what is being done in response to recommendations, it is trying to create other public accountability mechanisms as well through some of its recommendations. And then if we move on to the UK COVID-19 inquiry, obviously this is an inquiry that is not concluded and won't be concluded for some time, but is it issuing interim reports, interim findings and interim recommendations. And it has published on its website a page that has the heading Internal Monitoring of Inquiry Recommendations. And what is said there is that the chair expects that all accepted recommendations are acted upon and implemented in a timely manner. In the interest of transparency and openness, the inquiry requests that the institution responsible for each recommendation publishes the steps they'll take in response and the timetable for doing that. And unless otherwise stated, institutions should do that within 6 months of the recommendation being published. The inquiry has agreed an internal process to ensure effective monitoring of recommendations, which is set out below. And that monitoring mechanism is the one that's shown on the slide that you are seeing now, which effectively sets milestones at 3 months, at 6 months, at 9 months, and at a year after the recommendation has been published. So clearly the inquiry is taking a quite robust approach to monitoring recommendations that it makes. And the UK government again has published a really quite fulsome response to the inquiry's Module 1 report, which you can see on the UK government website, and that was published in January of this year. So hopefully that gives you a flavour of the kinds of things that inquiries are doing. And as I said, when we got to this section, I think the key takeaway is that there is greater opportunity for engagement, greater opportunity for participation, but undoubtedly a greater burden on core participants and those to whom recommendations are directed. Now, it, entirely coincidentally and not linked to that theme, we did also want to just give you a quick refresh on legal challenges to public inquiries, because it is possible to bring challenges to the decisions that are made by public inquiries. And again, the short takeaway, and it's not a big reveal, the short takeaway is that those challenges do not enjoy high levels of success. It is quite difficult to successfully challenge a decision of a public inquiry. That may or may not be because the challenges that have been taken to date have perhaps not been the best challenges. You do sometimes have to choose your case, and I think there is a sense that some of the cases that have been taken were probably bound to fail. So if we look first of all at the Cabinet Office against the COVID inquiry, that's the next slide. You will remember this case. This was concerned with WhatsApp messages and notebooks and diaries held by senior members of the UK government and their advisors. This was obviously about the planning that was being done and the response to the COVID pandemic at the time. And there was a concern expressed by UK government who, through the Cabinet Office, made an application for judicial review that the inquiry was using the Section 21 notice, which Caoimhe's mentioned before, but for those of you who maybe aren't so familiar, Section 21 is the part of the Inquiries Act that allows the inquiry to force people, whether they're participants in the inquiry or not, to force them to produce material documents, text messages, WhatsApp messages. It can also be used to compel people to come as witnesses if they are reluctant. The inquiry was using the Section 21 notice process to request very, very broad categories of documents, and Cabinet Office brought a challenge. Quite an odd judicial review, quite an interesting judicial review, because Cabinet Office was clearly acting in the broader interest of good government, if I can use that expression. It's clear that Cabinet Office was concerned about how such requests might occur in the future and whether they were consistent with good government. The Prime Minister, the then Prime Minister Boris Johnson, was also a participant in the judicial review, but strangely enough, he was on the side of the inquiry rather than on the side of Cabinet Office, while one of his special advisors was also involved because their messages were up for grabs. They took a fairly neutral stance on whether the inquiry should or shouldn't be able to get access to this information. So Cabinet Office's claim for judicial review was founded really on the concept of relevancy. So the grounds on which they brought the judicial review were that the Section 21 powers don't allow an inquiry to recover material that is not relevant to the work of the inquiry, and that you've got to be able to read any Section 21 notice that you receive. If you're someone who holds material, you've got to be able to read that as only including information that is relevant to the work of the inquiry. And the view was that if you took a different view, then the request that had been made was really an irrational one because it was so broad. And what was really, or one of the things that's quite interesting about this case is what the court says about the nature of an inquiry, and it comes back to some of the material that Caoimhe was talking about in her refresh. So one of the things the court says is that an inquiry isn't determining issues between parties to civil or criminal litigation. Rather, it is conducting a thorough investigation. So it's that distinction between adversarial proceedings and investigative or inquisitorial proceedings. And what the court goes on to say is the inquiry has to follow leads in the manner of a private investigator, and it's not bound by the rules of evidence. So the court's reasoning in this case is very firmly influenced by the nature of an inquiry and what it is that the court thinks that an inquiry is doing. And it goes on to say that the notice was served to require the production of documents that related to the inquiry generally, that under the Act, an inquiry does have the chance to fish for documents. Now, those of you who are lawyers or who've been involved in litigation that involves the production of documents will know that one of the objections to recovery in a court process is that the other side is fishing for material that may or may not be relevant. Well, here the court said you're entitled to fish for documents. And yes, it is very likely that you will be in a situation where you receive a notice that is going to return some material that might turn out not to be relevant, but that's okay. The inquiry is allowed to do that. And what's again just worthy of note for those of you who are involved in Scottish inquiries, the chair of the Scottish COVID inquiry also got involved in this case, but by written representations only, so not represented in the hearing. But unsurprisingly, the chair of the Scottish COVID inquiry, his intervention was in support of the position of the chair of the UK inquiry. If we move quickly on to Daniels against May, the May in question is Theresa May, then the Prime Minister, who was appointing the chair of the Grenfell Tower inquiry. This was a challenge effectively by relatives of some of those who had died in the fire, and they were concerned about the appointment of a judge alone as the decision-making body for the inquiry. Again, as you may know, it's open to the government not just to appoint a single chair, but to appoint instead a panel. And the suggestion here was that the Prime Minister ought to have appointed a panel rather than a single chair. And the grounds really on which that was argued related to the purpose of the 2005 Act. It was argued that the statutory purpose of the 2005 Act was to maintain public confidence, And that being so, the Prime Minister ought to have had that maintenance of public confidence as a key or prime factor in her decision making. And again, it probably to the lawyers was not a surprising outcome, but the court took the view that while the wishes of survivors and the bereaved was relevant on the question of who should be part of the tribunal investigating what happened. Their views couldn't be conclusive, and there was no real legal basis on which to undermine the Prime Minister's decision. And then finally, and this will be known to some of you in Scotland, the next slide deals with a case several years ago relating to the tram inquiry, and this is potentially a very important area. This was an attempt to judicially review or challenge a decision made by Lord Hardy in the tram inquiry that he would not protect from disclosure certain material that had been submitted by a party to the inquiry. They took the view that the information was commercially sensitive, it shouldn't be published, and there was an attempt effectively to suspend that decision and interdict the release of that information. That was rejected. But it was rejected as much as anything because of the nature of the challenge that had been brought, and there was quite a lot of discussion about um, the what was said to be the failure of the applicants in that case to provide a real explanation and justification for restriction of this information. And I think the point here is that if you're going to challenge decisions on disclosure of information, it's really important that you're able to be very precise and clear about exactly what it is that you want to see withheld, why you want to see it withheld, and what damage would be done if you don't withhold it. So that's just a reflection on some of the litigation around inquiries in recent years. Kiva, I think you're now picking up on the parliamentary side
I
to
am, yes, thank you,
finish us
Christine.
off.
So move on to the next slide. So um, Christine has given an overview of the different approaches being taken by public inquiries in terms of recommendations they make and sort of a next stage of a public inquiry. And this is something that has been picked up and acknowledged by um, the the government, and a statutory inquiries committee was set up last year to consider the law and practice relating to statutory inquiries under the 2005 Act. And the committee's report, which was titled Public Inquiries Enhancing Public Trust, was published in September last year. We're still waiting the government's response to that report. It was due in November last year. So we don't know their position on the findings, but we thought it'd be helpful to give a brief overview of what the committee has concluded and what the committee's looked into. And then I'll briefly go and look at the specific parts in relation to recommendations, as we've talked about this morning. So the committee found four main areas where the governance structure for public inquiries could be improved on. And firstly, they looked at the way that inquiries are designed and established. So, including looking at why a minister would choose a non-statutory over a statutory inquiry. And we touched on that briefly earlier on. There may be reasons such as national security and reasons that um, more flexible approach to an inquiry would be needed. And the committee looked at why non-statutory inquiries have been chosen in certain situations. They also said it can be improved on ensuring that the accepted recommendations from a previous House of Lords report into public inquiries are put into effect by the government. So there was a report back in 2014 that reached similar conclusions to this committee that wasn't put in place, wasn't enacted upon by the government back in 2014, and that report has been fully adopted by the Statutory Inquiries Committee. It also said that how public inquiry recommendations are monitored could be improved on to ensure they are implemented by the government. And that's what we've seen in the examples set out by Christine today, that inquiries are becoming increasingly aware that there's a little weight behind the recommendations they make, and the Statutory Inquiry Committee has looked at what the government can do to manage that ongoing monitoring. And part of that was enhancing the role of the Cabinet Office's Inquiries Unit. And so moving on to the next slide. So I'm just going to focus on giving a brief overview of the conclusions that the Statutory Inquiries Committee made specifically in relation to recommendations, because that's what we focused on this morning. And in their conclusion, the committee set out that insufficient implementation monitoring has damaged the reputation of public inquiries and made them less effective. This risks the recurrence of disasters and fails to provide victims and survivors with the clear reassurance that everything has been done to prevent recurrence of a disaster. Currently, millions of pounds are spent on public inquiries, yet too little is done to ensure that the desired outcomes of inquiries are achieved. Implementation monitoring is an essential but currently neglected part of the inquiry process. And the 2005 Act doesn't provide for any ongoing monitoring of recommendations. Um, and so the committee concluded that more scrutiny is needed to ensure that accepted inquiry recommendations are implemented to avoid the recurrence of disasters. And one of the examples they referred to in the report was that if the changes recommended in a 2013 inquest into a house fire had been made, then the Grenfell Tower fire might have been prevented. So they did look back and went beyond statutory inquiries to see what other inquests and inquiries, non-statutory, are carried out in the UK, and looked at what recommendations had been implemented. And I think that's one of the key risks, that if an inquiry is set up to look into certain circumstances, if those recommendations aren't implemented, that there is a risk that those events could happen again. And the so the committee recommendation made a number of recommendations. I put three on the slide here, and there are there was quite a few of them, and it was quite a lengthy report. But for the purposes of this morning, I've just focused on three, um, and to allow a public inquiry to discharge certain functions. So they, there should be one area where all inquiry reports are published online and along with the government responses. So rather than going and looking at the individual inquiries website, being able to go onto a portal on the government website and be able to find all the reports and the corresponding response from the government. They also recommended monitoring the implementation of accepted public inquiry and major inquest recommendations, so not limiting it just to statutory inquiries or non-statutory inquiries, but also inquests in England and Wales. Um, it also has recommended publishing reports on recommendations being implemented, showing the status of individual recommendations, and they've suggested a sort of traffic light system of whether they've been implemented, whether they're being considered by the government, or whether they've not been implemented, and or if any reason has been given for them not to be implemented. So it's kind of in line with the approach being taken by both the Infected Blood Inquiry and the UK COVID-19 inquiry. So as I said, there's been no response from the government yet to this report. It was due back in November. There doesn't seem to be a response coming imminently. But I think what we've seen this morning, looking at the three examples that Christine looked at, that there is a change, a movement in inquiries recognizing that there is an importance on and on them to look at how the recommendations they make are implemented and what monitoring they can do whilst the inquiry is ongoing. And there is a view that there should be more weight behind recommendations, but we'll have to wait and see what the government does in response to this committee report and also in response to the approaches taken by the current ongoing public inquiries. So I think that brings us to an end of the webinar presentation by Christine and I this morning. And I think if there's any questions, we're happy to answer those.
We'd be delighted. delighted to have your questions. So please, if you have any, put them into the Q&A function. We have only one so far, which is a question I enjoy, which is, would you recommend challenging the decision of an inquiry in court? I haven't done it, and I think in terms of litigation strategy, I would always say to a client that there's quite a lot to be thought about if you are genuinely contemplating a judicial review or other legal challenge to what has been done by an inquiry chair. I think in the case of Cabinet Office, for example, even though I think it's pretty clear that Cabinet Office was bringing its challenge on the COVID messages and the like for the purposes of, as I said, good government and trying to test what the Inquiries Act 2005 actually means as a matter of law. I think it went down very, very badly, and I think the challenge was was widely reported as a negative action by UK government. There has, in just the last few days, been publicity around a proposed judicial review by Police Scotland in relation to the Sheikh Ubayo inquiry. The reports suggest that that has been resolved, but clearly that has also generated some fairly negative press attention for Police Scotland. So there are definite reputational issues to be thought about if you are contemplating a challenge. On the other side of that, I think it is also fair to say that the 2005 Act is a not very well explored act in terms of the courts having the opportunity to think about and make decisions about just how far the 2005 Act powers go. And there may be, particularly around documents, information, disclosure of material, there may be situations in which a client feels that, notwithstanding any reputational risk, there are interests that are important enough to justify bringing the challenge. Very interesting point around judicial review, which is that there is a time limit for bringing certain challenges in England and Wales, which time limit doesn't apply in Scotland. The usual 3-month time limit applies in Scotland. So there'd be some interesting questions for UK inquiries about where you might bring a judicial review if you were tempted to do that. I am not seeing any other questions at the moment, and it is not our business to keep you longer than you want to be involved in these webinars. So, if there are no further questions at the moment, I think I would propose to wind things up. This is us. You've seen us before. We're really grateful to you for taking the time today to listen to us, and hopefully we will see you at a Brodies event in the future. Thank you very much. Have a good day. Bye bye.
Thank you. Bye.